There's something for us to watch tonight on the FX network at 10 o'clock. It's the movie, The People versus OJ Simpson, with Cuba Gooding Jr. portraying OJ Simpson. And we've just been playing some clips from that and talking about, you know, the case itself being groundbreaking and being taught in legal classes all over the country. What are your impressions of the power of that particular court case and how it's changed society?
That was probably one of the first court cases that was televised from start to finish, and people had an opportunity to watch the entire case. And I think what really happens in a case like that is people are under the impression that he's guilty, and when he is found not guilty, they say, well, he must have gotten off, there's some fluke. But then when you watch the trial day to day, you realize that there are issues with the evidence, and people, I think, became much more sophisticated in terms of DNA, in terms of what in the law calls the forensic evidence, which is the objective evidence, the hair follicles, the DNA test, the blood test. Those are something that people are looking for more and more today. And you find that in cases that juries are much more sophisticated because they are watching television and they understand the type of evidence that is available. And when you have a case where they don't have that evidence, the juries want to know why. And I think it's very important for people to become informed. And I will say that from the time I started practicing until now, that juries, particularly in criminal cases, are looking for the forensic type evidence, and if they don't see it, they want to know why.
Do you think it's changed also in the aspect of the evidence itself? You mentioned, of presenting the proper evidence. We all know about the glove and not fitting correctly or properly. Did that really change the way maybe evidence was presented in a court case?
Well, that was a gamble. And one of the things that you learn in law school, and most lawyers know, is you don't ask a question unless you know the answer. Mm-hmm. And when you start fishing and when you start saying, this is the glove, and you say, try the glove on, and it didn't fit, that's a big thing because people like demonstrative evidence. Mm-hmm. I think they listen to witnesses testify and they hear what they say, and people disagree. And we know that people's memories aren't the best. And there are studies that have been done to show that one of the most unreliable types of evidence is the eyewitness testimony because people really can't remember that clearly what they've seen. And there are tests that are done where they have various people observe the same event and they come up with different recollections of what happened. But with something like a glove, with something that's demonstrative evidence, that's objective, that's something that the people can't argue about too much, juries like that kind of evidence because they don't have to rely on somebody's memory or somebody's perception. And that's the kind of evidence that's very important in any court case.
Well, I'm not sure I bought the whole glove thing anyway. I mean, if you're trying a glove on, can't you kind of bend your hand and your fingers a little bit to make it ill-fitting? And who's to say he didn't use a glove that didn't fit him?
Didn't matter. It was the turning point, I think, in the whole case, Dave. Mm-hmm. As I think that goes back to kind of what Mark was saying. But you make a good point because I was going to bring that up. It was concrete, and it was almost the first thing I think Mark said. In law school, you don't do something unless you have the answer. And I think that really showed the viewers and folks following the case how this could unfold.
Yes, you sometimes take a gamble, and you ask a question, or you bring something out, and you take a gamble. And I've done it, and I've gambled on things, and I've been successful in my gambles, and I've been unsuccessful in my gambles. So sometimes you do take that chance. I'll give you a sidetrack, but I had a case where someone was accused of having had his car burned, and they claimed that he was behind in his payments because the June payment wasn't due until July. But I never brought it up, and I was leaving it hoping that the district attorney would bite on that and ask the person the question, and he did, and then we were prepared, and I had the answer right there. He said, well, you were behind in your car payment. No, I wasn't. I had the documents right there, and it shut down his argument completely. So I took a gamble that he would ask the question on cross-examination because it was an important part of the case. I didn't want to bring it up because I wanted to use it more dramatically and more effectively by countering something the district attorney did. But I took a gamble that he would ask that. If he didn't, then I wouldn't have been able to bring it up. But that's what I did. So it happens sometimes that you take a little gamble, and sometimes it pays off, sometimes it doesn't. Mm. But the type of evidence that people are looking for today is the photograph the DNA evidence, the things that are much more definitive, much more objective, where you're not relying on somebody's memory. And the other thing is, and we all know this, that lots of witnesses have motives and they have some reason to shade the testimony a little bit. So that always makes their testimony a little bit suspect. The best thing you can have in a case as a truly objective witness, you very seldom have that, because most of the time these things take place where people are among friends, and friends or enemies.
I'm talking to Mark Wolber, our legal correspondent on the Talk of the Town at 100.7 FM WUTQ. The interesting story above the fold today in the Observer-Dispatch is the case of the 18-year-old Henry Bartle, who pleaded guilty in Oneida County Court to felony second-degree manslaughter for the death of the 7-month-old Nathaniel Hitt, where Bartle, the defendant, was cleaning his shotgun after having smoked marijuana. What do you think of this particular plea, Mark? And does that change with regard to the fact that he had smoked marijuana? Will there be leniency on him because of that mitigating factor? What do you see occurring here?
No, I actually see the opposite. Let me just tell you what this youthful offender is. Any person who is convicted really of a crime or something that would be a crime, if the person is either age 16, 17, or 18, that person has the right to ask to be treated as a youthful offender. If it's the person's first time misdemeanor, then there is mandatory youthful offender treatment. So if your first misdemeanor and you're 16, 17, or 18 when the crime was committed, then you are eligible to be treated as a youthful offender, and you must be in that circumstance. If it's a person's second misdemeanor or third or beyond 2, or it's a felony, then youthful offender treatment is discretionary with the court. The court has the right to grant youthful offender status or to withhold youthful offender status. If the person is granted youthful offender status, the person will not have a criminal conviction. The criminal conviction would be replaced by a finding of youthful offender. For the most part, that record is sealed and cannot be looked at. Now, I say for the most part because there are some exceptions to that, but generally speaking, that's going to be a sealed record, and that would not be available to members of the public. Only in very limited cases could that be looked at. The sentence would be limited. I think it's in this case would be 1 to 4 years in state prison because the person's treated as a youthful offender.
Right.
Now, the judge could treat this person as an adult, in which case his age would be of no significance. Do I think smoking marijuana will be a mitigating factor? I do not. It has been our experience in the law that use of alcohol or other intoxicating substance voluntarily is not a mitigating factor. People are not impressed by the fact that someone smoked marijuana or was drinking alcohol and then engaged in some dangerous activity. It's not something that I don't think today people are looking at as any type of a mitigating circumstance. I don't think that will be. I think if what happened was he was cleaning the gun, wasn't aware it was loaded, it was truly a mistake, I think the judge would be more lenient than in a situation where he was engaged in a dangerous activity and was using some type of an intoxicating substance. That's adding two things together. That's not going to help him.
The grandfather of the victim claims it wasn't an accident. He's been very outspoken over the last 24 hours or so in his comments to the press, saying that he thinks there was intent involved and that he knew what he was doing.
There's no way to prove that except for unless he were to admit it. He admitted that he caused the death. He's admitted having committed the crime for which he was charged. It's almost impossible to prove whether he intended it or not unless you have a statement from him, but that's not going to happen.